New Mexico exam prep, page 26. C. Performance of any and all written agreements made with the prospective buyer, seller, landlord, owner, or tenant. D. Written disclosure of any potential conflict of interest that the broker has in the transaction, including but not limited to 1. Any written brokerage relationship the broker has with any other parties to the transactions, or 2. Any material interest or relationship of a business, personal, or family nature that the broker has in the transaction. E. Written disclosure of any adverse material facts actually known by the associate broker or qualifying broker about the property or the transaction, or about the financial ability of the parties to the transaction to complete the transaction. Adverse material facts requiring disclosure do not include any information covered by Federal Fair Housing Laws or the New Mexico Human Rights Act. 1. A buyer's inability to perform must be disclosed. 2. Brokers owe the following broker duties to the buyers, sellers, landlord, owners, and tenants to whom the broker is directly providing real estate services. Regardless of the scope and nature of those services, brokers working as property managers for a landlord, owner are directly providing real estate services to the landlord, owner, not to the tenant. A. Assistance to the party in completing the transaction, unless otherwise agreed in writing by the party to whom the broker is directly providing real estate services, including 1. Timely presentation of and response to all offers or counteroffers, and 2. Activate participation in assisting in complying with the terms and conditions of the contract and with the finalization of the transaction. If the broker in the transaction is not providing the service, advice, or assistance described above, the party must agree in writing that the broker is not expected to provide such service, advice, or assistance. B. Acknowledgement by the broker that there may be matters related to the transaction that are outside the broker's knowledge or expertise, and the broker will suggest the party seek expert advice on these matters. C. Advice to consult with an attorney regarding the effectiveness, validity, or consequences of any written document generated by the brokerage or presented to the party, and that has the potential to become an express written agreement. D. Prompt accounting for all money and property received by the broker. E. Maintenance of any confidential information learned in the course of any prior agency relationship, unless a disclosure is with the former principal's written consent or is required by law. F. Written disclosure of brokerage relationship options available in New Mexico. Page 27. G. Unless authorized in writing, A broker who is directly providing real estate services to a seller/owner shall not disclose the following to the buyer/tenant in the transaction. 1. That the seller/owner has previously indicated they will accept a sales/lease price less than the asking or listed price of a property. 2. That the seller/owner will agree to financing terms other than those offered. 3. The seller/owner's motivations for selling/leasing. Or 4. Any other information the seller/owner has requested in writing remain confidential unless disclosure in required by law. H. Unless otherwise authorized in writing, a broker who is directly providing real estate services to a buyer/tenant shall not disclose the following to the seller/owner in the transaction. 1. That the buyer/tenant has previously indicated they will pay a price greater than the price submitted in a written offer. 2. The buyer/tenant's motivation for buying/leasing. Or 3. Any other information the buyer has requested in writing remain confidential unless disclosure is required by law. I. In the event the broker is working for the landlord/owner as a residential property manager, the broker additionally owes to the landlord/owner all duties owed under the laws of agency. 3. In addition to the broker duties owed to prospective buyers, sellers, landlords, owners, and tenants as set forth in the section 16 61 19 8A. Brokers working as property managers for a landlord/owner owe the following duties to tenants. A. Prompt accounting for all money or property received by the broker from the tenant, including issuance of a receipt for cash received. B. If a residential property manager, written disclosure that the broker is the agent of the owner of the property and not of the tenant. In the commercial property management context, written disclosure of the broker's relationship with the landlord/owner. 4. Broker obligations to other brokers. Brokers owe the following professional obligations to other brokers. However, brokers are not required to provide to one another a list of these broker obligations. A. Honesty, reasonable care, and ethical and professional conduct. B. Timely presentation of offers to or counteroffers and responses thereto, unless otherwise agreed to in writing by the party to whom the broker is directly providing real estate services. C. Active participation in assisting the party to whom the broker is directly providing real estate services in complying with the terms and conditions of the contract with the closing of the transaction, unless otherwise agreed to in writing by the party to whom the broker is directly providing real estate services.